A very good morning, good afternoon, good evening, as the greeting goes wherever you may be. And thank you for joining us for this discussion on accountability for terrorist use of sexual violence. My name is Naureen Chowdhury Fink. I'm the executive director of the Soufan Center. For those of you who don't know us, we're an independent, nonpartisan think tank focusing on global security issues. All our work, our daily intel brief, our research and events are available online. So I invite you to check out our work and please do engage with the team on anything you'd like to know more about. I'm particularly delighted that we are able to have this very important discussion today, because even though the UN Security Council and member states recognize the use of sexual violence as a tactic of terrorism, we see that globally accountability for this crime remains relatively low. And this is even though the Security Council recognized that acts like human trafficking and the use of sexual violence to provide material support to terrorism could be a sanctionable offense, and one could consider, for example, the use of 1267 sanctions for some of these acts. We still see that generally uptake of these tools is relatively low. And of course, there's a great debate about whether sexual violence is to be prosecuted as a terrorist crime, war crime, another type of crime, or in fact prosecuted at all, which is quite a challenge to this day. And I know many of our panelists will be picking up these issues. So I think it's really important that we continue to keep this topic in the limelight, that we continue to challenge member states, stakeholders, the UN system to really make use of the tools that are available and ensure that the debates don't cloud the urgency to achieve some kind of accountability, and ensure that the victims see justice being done and receive justice for what they have been through. So I think it's really important, as we have discussions throughout this week at the UN on supporting victims and survivors of terrorism, that the question of accountability, which often isn't on the agenda in that discussion, actually remain front and center. It is great that the Security Council and others have taken up the topic. I'm delighted there will be an ARIA formula hosted by Malta on Monday on the issue of gender and counterterrorism. I hope this issue will come up, and we are delighted to have Adria Delandry with us representing IIJ, who is supporting that event, and I'm sure we'll hear a bit more about it. And it gives me great pleasure, and it is with deep appreciation that we thank the UK for co-hosting this event. The UK has been a strong supporter on this topic, and I know has paid great attention to challenges related to modern slavery, counterterrorism, and gender. So it's wonderful to have you with us, Jonathan. And with that, I would like to give the floor to the United Kingdom mission to the UN for some opening reflections. Jonathan, the screen is yours.
Thank you very much, Naureen, and good morning, everyone. As Naureen said, my name is Jonathan Hollis. I'm a legal counsellor here at the UK mission to the United Nations in New York, and I cover, among other things, legal aspects of sanctions, terrorism, and conflict-related sexual violence. So given my intersecting interests, I'm very delighted to be able to introduce this event on behalf of the United Kingdom. And let me thank the Soufan Center for organising this event and all the panelists for joining in. We're very thankful for the excellent work the Soufan Center is doing, particularly on counterterrorism. And turning to today's topic, it is clear that despite international efforts over the past 10 to 15 years, sexual and gender-based violence continues to devastate the lives of survivors, their families and communities. The UK is nevertheless continuing its long-standing commitment to tackling it. Recently, following our Preventing Sexual Violence and in Conflict Initiative conference last November, we launched a new 3-year strategy backed up by £12.5 million of new funding. That funding supports a range of activities to prevent and address conflict-related sexual violence, including our Act for Survivors initiative to strengthen justice and accountability at the national level, and crucially through direct support to survivors. We've also funded recently an online guidebook on state obligations on CRSV, which was released this week. It's produced by the McQuagey Foundation, and the guidebook is online and supports states around the world to understand and comply with their international law obligations on CRSV. So with this in mind, the UK is keen to ensure terrorists are held accountable for their use of sexual and gender-based violence. We have therefore supported UNITAD's mandate to investigate international crimes committed by Daesh in Iraq, including sexual and gender-based crimes. And we are pleased that UNITAD's work has contributed to the prosecutions of terrorists, and we hope to see their work contributing to prosecutions in Iraq, as well as to sanctions designations, perhaps at the United Nations. We are clear that the 1267 regime supports sanctions against terrorists who use sexual and gender-based violence. The UK supported language in Resolution 2610/2021 to target sanctions for individuals and entities associated with ISIL and Al-Qaeda involved in sexual violence in conflict. But we should look to use other sanctions regimes where possible too. For example, we supported the Security Council's decision to sanction Sultan Zabin for violent reprisals, including sexual violence against politically active women in Yemen. Clearly, these actions are just the start. I'm therefore very much looking forward to our panel discussion today, which I hope will explore the effectiveness of the tools we have and provide ideas for what more the international community can do. So I'll be listening in carefully. Thank you very much, and back to you, Naureen.
Thank you, Jonathan. And once again, thank you to the UK for all that support and for being here today. Before I hand over the floor to our moderator, I just want to invite our audience members to please go ahead as you think of questions or points to raise during the discussion session, to please go ahead and add them into the chat. We may not get to all of them, but I know that our team is going to try and address as many of those questions as possible. It is now my great pleasure to hand over the screen to Dr. Colin Clark, who is a senior research fellow at the Soufan Center, one of the beating hearts behind all the great work that you see online in our events. So I'm really delighted to hand over the screen to Colin, who will take us through this really exciting discussion. And I get to sit back and enjoy it and engage now. So Colin, the screen is yours.
Thanks so much, Naureen, and thanks to all of our attendees and our panelists as well. And we'll be discussing various tools to deliver justice for both survivors and perpetrators. We'll map the state of prosecutions for terrorist crimes at the intersection of human trafficking and sexual violence and conflict, and discuss various policy recommendations. But it's my pleasure to introduce the panelists now. We've got Tanya Mera, who is a senior research fellow and program lead for the Rule of Law Responses to Terrorism at the International Center for Counterterrorism in The Hague, ICCT The Hague. With a background in international law, Tanya is involved in conducting evidence-based research, providing policy advice, advising governments on a rule of law approach in countering terrorism. Previously, she worked at TMC Asser Institute, where she was engaged in capacity building projects and developing training programs. Tanya's main areas of interest are international criminal law and rule of law approaches in countering terrorism, with a focus on bringing alleged terrorists to justice for the full range of crimes they've committed in full compliance with human rights. This includes researching prosecutorial strategies, collecting information from the conflict zone, and the use of administrative measures in a counterterrorism context. In addition to accountability for terrorist offenses, Tanya's research also looks into the accountability of states and international organizations for developing and implementing rule of law compliant CT strategies, laws, and policies. When we're very glad to have her here as a panelist today. Adria Delandry joined the IIJ as a resident fellow in the academic unit. In 2021 is responsible for designing and delivering cutting-edge courses to effectively counter terrorism and transnational crime, as well as developing the IIJ's research agenda. Prior to joining the IIJ, she served as a legal officer at the UN Security Council Counterterrorism Committee Executive Directorate, which is responsible for assessing member states' implementation of Security Council counterterrorism resolutions. In this capacity, she organized visits to member states and presented findings to the Counterterrorism Committee, reviewed domestic legislation in a variety of jurisdictions to verify compliance with Security Council resolutions, and provided authoritative legal advice on diverse legal and counterterrorism matters of high complexity, while also conducting numerous technical assistance projects for judicial and law enforcement officials on a variety of topics related to terrorism financing, and other complex crimes. She was also a trial attorney in the Office of the Prosecutor at the ICTY. Very pleased to have her here. And we've done some work with the IIJ, and I always enjoy the various briefings and presentations. Finally, we have Adejoke Babington Ajay, who is a senior research fellow with us here at the Soufan Center focusing on legal and criminal justice responses to terrorism, including in Africa, and with a focus on accountability for sexual and gender-based violence. Adejoke is an expert in international law with expertise on a broad range of strategic, legal, and policy issues in international law and justice, accountability in the context of terrorism, and international criminal investigations. She's an expert trainer who provides technical capacity building training to national criminal justice stakeholders on the investigation and prosecution of conflict-related sexual violence and crimes committed in the context of terrorism. Adejoke's work experience includes the World Bank, the International Court of Justice, and the International Criminal Court, where she worked as an investigator. She holds a Doctor of International Affairs and a Master of International Public Policy from Johns Hopkins University, as well as an LLM in Public International Law from the London School of Economics and Political Science. She's a qualified attorney at law in the state of New York and is the co-editor of International Criminal Investigations, Law and Practice for 2015. We're very happy to have her here today. And let me begin by having the honor to turn the floor over to Adejoke for her initial remarks. So thank you very much and looking forward to the event.
Thank you so much, Colin, and thank you very much, the organizers, for this really important webinar. I'm looking forward to the discussions. I'll start off with a few thoughts regarding the tools, regarding reasons why, at least from where I sit, we're sort of lagging behind in terms of implementation and accountability, and then also some thoughts for the way forward. So from where I sit, definitely, I'll start off by saying that there are multiple legal frameworks, multiple laws that are applicable and available to deliver justice for the victims of SGBV committed by terrorist groups. I recall some time back speaking with a national prosecutor who mentioned that, you know, in their jurisdiction, the laws are not the problem. They have very beautiful laws. Implementation is the key. So why is implementation then lagging behind? I think all of us will agree that political will is a key issue. And when we talk about the lack of political will, I think it's important to understand the why, what is driving this lack of political will. So of course, the different perspectives. Some that come to my mind are, first of all, the need to overcome the notions of what constitutes terrorism. So you do have some states that have specific ideas of what constitutes terrorism, and unfortunately, SGBV is not included. You have a very masculine framing of war and harm that ultimately shape the narrative of what constitutes terrorism. And even to this day, SGBV is often sadly synonymous with, or viewed synonymously with, women's issues. And if you have this very masculine view, then women's issues, in quotes, are not considered to be core issues that could have a direct impact on peace and security or a causal link with instability, right? So even though we have Security Council resolutions that have acknowledged that SGBV committed by terrorist groups can have an impact on peace and security, that negotiated language of a Security Council resolution, the language does not necessarily reflect the perspective of CT practitioners, law enforcement at the ground level where implementation actually matters. Then, of course, you have this discussion about prioritizing SGBV, the realization it's a recent conversation. It hasn't, been there since 9/11. And so for states that are currently dealing in or engaged in conflict, for them, they may be looking at accountability differently from another state, right? So for those who are engaged in conflict and are trying to end the conflict, the priority is on neutralizing the threat and going for low-hanging fruits from a criminal justice perspective. So that's why you may have then a lot of cases that are focused on terrorism-related offenses such as membership or providing support to a membership organization, rather than expending what they may consider to be limited resources to investigate the more substantive crimes like SGBV. So this is just some of the why, and I'm sure we will get into other ideas of why we're here. Regarding the tools that are available, as we know, we have the core international crimes frameworks that are available. Also, counterterrorism legislation, from my perspective, I think is actually a really important legal tool that could be used. And very often when I discuss this, I get pushback concerning CT legislation that it's a framework that's not suited to address SGBV. And I'll just point out one point, that while it may not be suited to address all forms of SGBV, it's still very possible to use this legislation to address forms of SGBV that entail grievous bodily harm or kidnapping, for instance, as a way to bridge the impunity gap, because otherwise you have nothing being done. And when you're dealing with states that do not have jurisdiction over core international crimes, and perhaps maybe all they could use is the counterterrorism framework, by insisting that they don't use that, you are essentially allowing the impunity gap to widen. And so an example of a state that did not have jurisdiction over core international crimes and is trying to use their CT legislation in an innovative way is Nigeria. And in 2021, the federal prosecutors filed charges against a former Boko Haram militant for the underlying crimes of rape, forced marriage, and kidnapping as an accessory after the fact, for the kidnapping and forced marriage of one of the girls that were abducted in 2014 from Chibok. So this is an interesting way where they're recognizing the limitations and challenges that they have in their legal system, but recognizing that these acts did not occur independent of terrorism, they occurred in the context of terrorism and should be prosecuted as an act of terrorism. So then real quick, what's the way forward, or what are some points that we can think about? From all the research and work I've been doing in this area for some time, I would say it's very clear that incentives are needed. We can talk endlessly about the horrors of SGBV. We can have victims, talk about the experiences. I don't think that is sufficient on its own to move the international community to fully address the lack of accountability. Incentives are needed. When we look at terrorism financing, you have the FATF gray list, you have various incentives for states to criminalize terrorism financing, and if they fail to do so, they risk economic impact. We need to start thinking that way about SGBV, because SGBV committed in the context of terrorism can also have significant impacts. A second key point I would say is there needs to be a discussion around who is the victim of terrorism. So for a long time, there's a perspective that the state is the victim. And so the responses then are securitized. And even though it's very clear that SGBV doesn't occur in a vacuum and it's occurring in the bodies of individuals, some states and some people are still struggling with that sense of recognizing that the victims of terrorism actually need a concerted effort is needed to ensure accountability, and not just a securitized response to terrorism because the victim is the state. And so we need to focus on what the victim, in quotes, the state needs. I guess also, we'll be remiss if we don't mention this, that we can't discuss SGBV by terrorist groups without acknowledging that the lack of accountability for SGBV is across the board. So it occurs in the continuum. It doesn't materialize only in conflict. There isn't a situation where there's no SGBV in the world until a terrorist turns up. That is not the reality. And so we have to address this even in quote unquote peacetime. So for example, earlier this month, there was an EU-wide bid to classify all non-consensual sex as rape, and that was rejected. And currently you have 14 member states of the EU that either require some violence to demonstrate rape or doesn't mention lack of consent at all. And this is important even in the conversation about SGBV by terrorist groups, because it demonstrates a gap in the domestic legal frameworks that must be remedied to be able to adequately respond to the realities of how rape as one form of SGBV can be committed, whether this is the context of terrorism or in domestic and peace setting. And I'll leave as a final point that it's important for us to think outside of the box when we're talking about accountability. There is a lot of focus on criminal justice accountability, which as a criminal justice practitioner, I am definitely interested in that and I want to engage in that. But as Naureen mentioned, there are other tools such as the sanctions regime. There are also transitional justice mechanisms that can be useful in conjunction to give a semblance of justice. And when we focus a lot on the criminal justice responses, especially without consideration of the views of the victims and the affected communities, we ourselves are doing injustice to those that we claim to be working for. So I'll leave it there, and I look forward to the conversation.
Thanks so much, Adejoke. Really a lot of food for thought there. And I thought the example of Nigeria was incredibly illustrative, and maybe we can talk about that more in Q&A. Before I turn to Tanya, let me just, my fault for not introducing the IIJ properly and spelling out the acronym. You can tell I worked for too many years with the Pentagon, and I'm a little bit too comfortable with acronyms. So the IIJ is the International Institute for Justice and the Rule of Law. Also, SGBV, for those wondering, is sexual and gender-based violence, right? The main theme of this. And then let me lastly just say for the audience to submit questions for the Q&A response. But please let me now turn it over to Tanya Mehra. So Tanya, the floor is yours.
Thanks, Colin, and thanks, Joke, for setting a bit the scene. And I think it's important to zoom out a little bit and also take a broader picture and to look at the context in which SGBV crimes are being committed and it is mostly during a conflict. And while we are going to be focusing a lot on SGB crimes committed by terrorists, we do need to be aware that many of the crimes are also being committed by state actors and non-state actors, which are not designated as a terrorist group. So we do need to have a holistic approach when we are talking about addressing SGB crimes, both from the prevention perspective, but also from the accountability perspective. And I agree that, there are many mechanisms and tools we can address and look how we can improve the accountability. And later on, maybe during the Q&A, we can focus a little bit more on the sanctions. But what I would like to do is walk you through some of the legal framework options, so more the criminal justice responses which are possible. And as Joke said, it's not in all the countries a lack of law, but it's a lack of implementation. And what you see is that there are substantial impediments, there are procedural impediments, and there are practical impediments. And yes, there's a big component, which is indeed a lack of political will, but I think there's also an issue with some of the legal issues to be able to prosecute SGB crimes. So as Joke pointed out, yes, there are possibilities of prosecuting them potentially as core international crimes. Rape can be prosecuted as a war crime, but many of the other crimes that are being committed amount to torture or cruel treatment and can be prosecuted as persecution, as a crimes against humanity. And just recently, the Special Rapporteur for Afghanistan issued this report in which he also elaborated a lot on the gender-based persecution which is taking place at the hands of the Taliban in Afghanistan. So besides as a core international crimes in some countries, they have not simply implemented the core international crimes, which makes it more difficult indeed to prosecute for those crimes. And in a way, it is indeed to some extent easy to rely on terrorist offenses because then you don't have to go through the full range of activities that they have committed. And many countries rely on membership of a terrorist organization, and committing bodily harm is covered in many of these terrorist offenses. And there are just maybe a few exceptions where they specifically mention sexual and gender-based violence crimes as a terrorist offense, like in Tunisia, and I believe also in the Gambia. And it's also possible to consider prosecuting some of these crimes just as domestic crimes. And that may not sound the most, obvious way, but it does offer in some countries certain advantages because the prosecutors are more familiar with the domestic offenses, but at the same time, it may not offer the range of crimes that actually have been committed, and they would, for example, only allow the prosecution of rape, but not many of the other sexual violence crimes. I think on the procedural side, it's also good to have a look at some of the procedural impediments. If you would prosecute sexual and gender-based violence crimes as core international crimes, there's no statute of limitations, which may be applicable when you would want to prosecute them for domestic crimes. In some countries, you would need 2 witnesses to state that rape has been committed. Or there needs to be a criminal complaint by a victim to open an investigation. So these are all barriers which doesn't make it very easy to actually start prosecuting such crimes. And then more at the practical level, it also requires a lot of experience and expertise among the prosecutors and investigators, how to deal with such crimes, but also how to question the victims and witnesses. So, and I'm sure Adria will be mentioning it a little bit more, that the need for training is going to be very important in that area. At the same time, I do think there is a wealth of information available through the jurisprudence of the international courts on how one could prosecute sexual and gender-based violence crimes as international crimes. And I do think that that needs to be shared and needs to be brought also so-called to the domestic level. So I think these are just a few observations. I have more on the legal side, and I think what it basically means is that it doesn't mean one size fits all approach will work. How you would address sexual and gender-based violence crimes committed in the Netherlands or in Germany is going to be very different how it looks like in, for example, Nigeria. And just to give you a few examples, that in Germany and in the Netherlands, there have been now several female returnees that are being prosecuted for their role in aiding and abetting rape and enslavement as a crime against humanity. So this is, I think, something relatively new what you're seeing. And at the moment in the Netherlands, there's also one female returnee, Hasna, who has been repatriated earlier this year, and her trial hasn't taken place, but it's also going to be including enslavement charges. So although these crimes have been committed not in the Netherlands or in Germany, but they have been committed elsewhere, I mean, they are being prosecuted for their role in facilitating and aiding and abetting sexual and gender-based violence crimes. So I do think that that is a very important development. And maybe the last point I want to touch on before I hand over the floor back to Colin is the role of victims and witnesses. And it's not only about the role of victims inside the courtroom, but also outside the courtroom that really needs to be taken into account. And also, you know, the access to the courts, but also their right to information and their right to reparation. And you see that the role of victims is different in civil law countries and in common law countries, where in one they have the possibility to intervene, and whereas in civil law countries they are really they can be a civil party. So I think there is still a lot of more research that needs to be done to look at how to ensure that you take the role and the rights of victims more into account when we are going to be focusing on accountability through the criminal justice system. And I hope we can also discuss a little later the possibilities of sanctions as well. So thank you very much. I'll leave it at this comment.
Thanks so much, Tanya. I really appreciate it. And again, more examples that, you know, kind of highlight for us some of the challenges, but also some of the promise, I think, in, you know, really kind of making this an issue more current. So we're seeing a couple of questions filter in. Please, for those watching at home or wherever you are, please continue to send in questions and we'll tee those up for the panelists. But next, I'd like to turn to Adria de Landry, please, for your remarks. So the floor is yours.
Thank you, Colin. Good morning, everyone. Thanks to Soufan for including IIJ in this very important dialogue. I think the extremely rich comments of my predecessors here on the panel have already demonstrated how important a topic this is and how important, just as frustrating as the slow progress that we've seen internationally can be, it's refreshing to be involved in a dialogue like this because it does show that people are paying attention. Governments, CSOs, academic institutions, bar associations are paying attention to this. And I would just draw a little bit on what I think all of my predecessors mentioned. In the context of war crimes tribunals, there has a lot of progress has been made. So I am hopeful that in the context of the counterterrorism and national security arena, we can mimic some of that progress. It's easy to forget that when the ICTY, the Yugoslavia Tribunal, the Rwanda Tribunal started, it was by no means clear legally that rape and other crimes of sexual violence could be considered war crimes or crimes against humanity. And that is now well established. If any of you think back to the war crimes tribunals that were set up after the Second World War, such as the Tokyo Tribunal and the Nuremberg Tribunal, there was no such thing as a prosecution of rape or sexual enslavement. So progress has been made, and I see that progress in the war crimes arena as completely transferable to the arena that we're talking about now. And I'm aware of how difficult it can be to translate the words of the council resolutions into action for a variety of reasons, not the least of which is political will, but some of the capacity reasons that I think Tanya started to mention. I will say from my perspective, as a national and international prosecution, these crimes are difficult to prosecute and prove for a couple of really basic reasons, regardless of whether we're talking about in a national context or transnational context, in the war crime or terrorism context. They often involve forensic evidence. A lot of states have very low capacity in this area, particularly in areas where terrorist groups may be very active. Sometimes those regions are extremely remote. So if in the capital of a country there is capacity to deal with forensic evidence, up in the border where these crimes are being committed by groups such as Boko Haram, local law enforcement, military, whoever the first responders are, they may have zero capacity in that area. So that is a threshold consideration, because there's always the need in these cases for forensic evidence, and it's forensic evidence of a specialized kind that is not typically called on in terrorism cases where there would be explosive experts, commonly trained to deal with crimes of terrorism. I would also say that, as is commonly known, these crimes involve reluctant witnesses. Not only is there's the reluctance to relive the trauma of the crime, there are a lot of cultural taboos that preclude effective enforcement, even when the adequate capacity and the political will and the legal frameworks exist. So it takes a lot of determined effort, really sustained effort on the part of anybody who's doing capacity building in this area to be attentive to that, to be sensitive to it. So hopefully over time, it can be eradicated. And I would also say, based on some of the work that IIJ has done in this area and the challenges that we've seen to effective capacity building, one is an inadequate stakeholder, and by that I mean local community stakeholder, in various capacity building programs that are intended to address this issue. So I think we can all work together in being more attentive to that. I would also say, as was mentioned previously, states view themselves as victims of these crimes. That's a fair perception, but it's not an adequate perception. All crimes of terrorism have individuals and states as their victims, whether they're crimes of sexual violence, murder. So we should not allow that to be an impediment to the effective investigation and prosecution of these cases, because there doesn't have to be, we don't have to narrowly define victim or victimhood. It doesn't just encompass the crimes of terrorism always involve the death or injury to individuals. So I think we need all to be mindful of that. But I see that time is ticking away. I don't want to take up too much time because I know we want to really have a very lively and interactive discussion. So with those few observations, I'll turn the floor back to Colin and be ready, willing, and able to answer any questions I may be in a position to respond to.
Thank you so much. And some really important points there, I think, particularly on what lessons we can learn from the past and how, while now more commonly accepted, what did happen during the Yugoslavia trials was revolutionary at the time. And I think it's, it's important to highlight that, right? Especially when we're thinking or maybe feeling frustrated at the lack of progress in some of these cases, that it does take time and sustained effort, as you mentioned. So I do want to turn to some of the questions we have now filtering in from the audience. So we have a question that says, Adejoke mentioned the possibility of using transitional justice processes to ensure accountability for SGBV in terrorism contexts. I wonder if she or the other panelists could expand on this point and the role of non-judicial mechanisms in this space. So Adejoke, I'll let you answer that. And then if Tanya and Adria want to jump in, please follow. Over to you.
Yeah, sure. Thank you. And that question was from Saren. Thanks, Saren. So I think definitely not to the exclusion of criminal justice, but I think that mechanisms such as truth-telling, reparations, these are important aspects that can be and should be considered in conjunction. Because if we focus on criminal justice alone, and we're right here talking about the lack of accountability, we're talking about, very few cases have been brought, then it means that a victim's right to truth is denied if you don't have any cases on SGBV, right? Also, while it's important, of course, to focus on and address the issues in terms of what has happened to a particular victim, you also have opportunities through transitional justice mechanisms, opportunities for communal healing and communal rehabilitation that criminal justice responses are not designed to provide. So that is why when I mentioned it, I was referring to thinking holistically about accountability and about justice.
Tanya or Adria, do you want to jump in on that?
No, I agree with what George is saying. I think it's also very culture and context specific, and the extent to which the crimes have been committed. If you're talking about indeed foreign fighters who have returned to Europe, it's a very different situation than when you're talking about a country which is massively been affected by the commission of sexual and gender-based violence crimes. I also think it depends also, we always talk about victims as if there's one type of victim. And I think we need to acknowledge that victims may not always want the same. And one would say, yes, I would like it to go to trial. The other may say, I do not want it to go to trial. I have much more needs outside of a courtroom. And also membership offenses, in a way, I always call them, they are faceless crimes because you don't really put a face to it. But they are, for some victims, they rather have a long sentence for a membership offense without putting them, exposing them and reliving and re-traumatizing. Whereas others, they would say, I would want it to be acknowledged that what wrong has been done to me. So I do think we need to also differentiate what victims want. That also may make a big difference. Yeah, I'll leave it at that.
It actually dovetails nicely with a question we got on victims, and this is directly to Adria, which is, you said that states view themselves as victims. Could you please elaborate on this and how it affects policy and legal implementation?
Well, I think that's a difficult question because, as we all know, there's no internationally agreed upon definition of terrorism.
Exactly.
But I think in at least one council resolution and some of the international conventions, we know that it involves it frequently is defined in those contexts in the conventions as involving a political motive, as opposed to motive to harm a particular individual or organization. So that sort of brings it up to a political and an institutional level. Does it affect policy and implementation? Absolutely. The crimes of terrorism become politicized for that very reason if the state views itself as the victim. And certainly if the state views itself exclusively as a victim. But again, I don't think that, that's not a definition that should be accepted. And I think as a matter of logic, it makes no sense. There's no way. I mean, you don't have to be an expert in, in prosecution or in international law to know that these crimes, even when they don't involve sexual violence, they involve harm to victims and large numbers of victims frequently, and that's why they're so powerful. So I think we need to really, make an effort to reject that characterization. And unfortunately, that is one of the aspects of politicization of this dialogue and of these definitions. But as somebody who had worked most of their career in the legal field, I am of the view that accountability is utterly key. It is important on a policy level to make sure that the victims who suffered at the hands of internationally agreed upon terrorist organizations such as Boko Haram or ISIL, their suffering should not be fully acknowledged in the field of terrorism. But I also am of the view, as a practical matter, offenders have to be brought to justice, and the conditions may not be optimal, and that's always true. That's not just true in the case of transnational crimes. That's not just true in the case of crimes of terrorism. Prosecutors often lack tools to bring what they would view and what the government might view and what the victim might view as the most appropriate optimal charge. But the reality is you are forced to work with what you have. And the important thing is that the victims receive a measure of justice, and that, after all, the community be secured from these individuals, because they don't just pose a threat to one group or one individual. They're very dangerous people and individuals.
Yeah, very well said. I think that sums it up quite nicely and a really comprehensive answer to a difficult question. I would like to ask about sanctions, and the question is along the lines of, what are some of the pros and cons of using sanctions, and how can we encourage states to put forward more listings? And that's a question to anyone on the panel that wants to take that one. Tanya?
Maybe I can start, but with the easier part, and then end with the difficult part, and hope that my panelists will be able to join.
Okay.
I think it is becoming, it is being discussed more whether or not sexual gender-based violence crimes should be included if you want to sanction. And there are not that many examples yet, but I do feel I'm hoping we're getting towards is going to be more of a momentum. First of all, I know that the UN team of experts are trying to make sure that SGB crimes are also mentioned for those who are already listed. I think that's a very good step if we can get there. So you are acknowledging that those crimes are just as serious as the other crimes that they have committed. So that's one. I mean, I'm aware of one person, Osama Al-Kuni Ibrahim. I mean, he's listed since 2021 under the UN Security Council Resolution 1970 for Libya for being responsible for SGB crimes in detention centers. Under the EU Global Human Rights Sanction regime, they specifically also mention rape and other forms of torture, which could lead to people, persons and entities to be listed. And in March this year, they have actually listed 2 Taliban ministers for issuing decrees limiting the freedom of movement of women in public spaces and their access to education. I think that that is a good step forward. And yes, there are also other persons indeed included on the list, which are state actors, but that's what I mentioned again. You have to approach it holistically. You cannot just only zoom in on only SGB crimes committed by one group. Of course, we have the mechanisms of the sanctions list 1267, which you cannot use. I mean, when it is being committed by non-state actors or by state actors. So I do feel little steps, but I mean, it is being discussed more. And then to the more difficult part, the pros and cons. I think it's the pro is simply also just recognizing it and making a very clear, I mean, statement that these crimes are not acceptable. I do hope, but that's more a hope than a real pro, but I think that also applies to the criminal accountability, that it also has a deterrent effect in the future. Both if you prosecute, but also by sanctioning. And it really depends whom is being sanctioned, whether it would really affect them as an individual, because there will be travel bans, there will be an asset freeze, and funds are not being made available to them. So it might affect the financial situation, but I really think that would be on a case-by-case basis. You would need to assess whether it would really make a difference to that particular person if you impose those sanctions. But I'm curious to hear also from the panelists what they think about the pros and cons of using sanctions, in addition to indeed, I mean, criminal accountability, which remains still very low. So it's also like we don't have that many measures yet to hold them accountable.
Adejoke, did you have some thoughts on this?
I thought Adria was going to say something.
Oh, I'm sorry.
Yeah.
Please.
No, that's okay. I think it's important to use all tools available, and sanctions would be one of those tools. But as Tanya mentioned, I think there's very little in terms of the actual criminal accountability. And I guess my bias is slightly in favor of bringing a measure of justice to victims in the community, and in the short term, at least, and particularly in the current criminal and political context, I would favor putting more resources and more attention into building criminal justice mechanisms. When you think of some of the places where these crimes in the context of terrorism have been committed, they're often very remote. They would not only involve low capacity in terms of the legal system, but just in terms of the level of education of the victims, their access to information. How is sanctioning their perpetrator really going to have value for them and have meaning? Sorry, Naureen. I don't mean to be downplaying the importance of the sanctions. I think they are important, and particularly in international context. But just trying to take the view of the victims, and also having seen how politicized the sanctions regimes can become, I would, my priority for the application of resources would be on a more local level and into criminal justice mechanisms.
Okay, so if I could just jump in there. So I agree with what both have said in terms of, there are benefits to using the sanctions regime. And I think we are seeing sanctions being, designated, and like people being designated for sanctions in other aspects. So why not SGBV? Why is this seen as something that is too difficult to do? It isn't. I think it was last year, there was for Haiti, where it was noted, those who are involved in destabilizing Haiti, including SGBV, could be designated for sanctions. So that's great that you can see it in that context. So when we talk about in the context of terrorism, why? I feel like why is the prevailing question that I'm asking throughout this whole thing, because I think if we understand the root reason why states are not doing what appears to be obvious, then we can develop the necessary strategies. And I understand the point about limited resources, but I don't know that the resources required to push states to designate and impose sanctions there's competing resources between that and criminal justice responses. And I think it will mean something to the victim in a remote place if the person who's responsible at a higher level for financing and strategize the SGBV is sanctioned, because then you go into one of the points of the benefits of sanction, where it can have that deterrent effect, of course, but also hopefully preventing more violence, because you're limiting the capacity of that terrorist group to act in that manner. So if we can see that it's necessary to sanction those who are involved in finance and in general, let's also make that link to be able to see that by limiting them in that way, it can also hopefully result in fewer instances of SGBV committed in the context of terrorism. The con that Adria mentioned is, an important one about how politicized it is. And also, I've also heard from others about the challenges where the standards are low. Sanction regime is not a criminal justice response. So we are not looking at having that same evidentiary standard. And I would say that, yes, these are challenges and problems that should be addressed. We should focus on it, rehabilitate the system, if we can use that term, but it doesn't mean that we shouldn't use it.
Some really important points there, including on deterrence and prevention as well. We're coming toward the end of the webinar, but I do want to throw out another question or two if we have time. We've got a question from Judith Naureen, who asks, what will be the effect of the fact that the Syrian Kurds are planning to prosecute ISIS perpetrators in their prisons themselves? Will they be able to also conclude SGBV? I don't know if anyone has thoughts on that case in particular, and whether or not sexual and gender-based violence crimes could potentially be part of what the Kurds are looking at.
I have been in touch with some of the judges through Rojava last year, and as far as I am aware of, they are mainly have been prosecuting, Syrian nationals, not Iraqi and other foreign nationals. It's a very complicated issue. It starts with, are they able to establish their own court, and what kind of standards do they apply? They have adopted some laws which would allow them to prosecute mainly terrorist offenses, including membership offenses. As far as I'm aware of, they have not criminalized and implemented core international crimes. So I wouldn't know in which context, because there are many ways you can prosecute them. You can recognize that these crimes have been committed as being a member of a terrorist offense, or whether they want to do it as rape, but certainly not as core international crime. So I'm not sure in how far it would be and could be part of their prosecutorial strategy, but yeah, it's not a lot of reliable data also coming out on how these trials are taking place, and what kind of sentences and what kind of
been following it closely myself, and have also seen fairly limited information. We do have a question from Marcia Mueller, who asked that, she said, Adejoke said that rape is one form of SGBV. What are the others?
Okay, so Marcia, so SGBV is sort of an umbrella term for sexual gender-based violence. In terms of other forms of sexual violence, you have forced marriage, you have forced pregnancy, forced sterilization, so acts or attempts of a sexual nature. And regarding the gender-based violence, then you have violence or harm against the person on the basis of their gender. So there are various forms in that sense. Hope that helps.
Thank you very much. And I think we maybe have time for one last question. This is from Mahande Joshua, who asks, how do we deal with SGBV by terrorists who are presumably too young to commit crimes that fall under SGBV, but also in the context of those kidnapped and find themselves forced to commit such crimes? So I don't know if that's a direct reference to Boko Haram and the case you referenced in Nigeria, but that's our probably our last question as we're coming up near the end of the webinar. So, and that was specifically for Adejoke.
Okay, sure. Thanks, Mahande. So I would say definitely from an international criminal law perspective, there's consensus that those who are children should not be prosecuted. You know, those who are victims of trafficking, kidnapping, for example, traffic for the purposes of committing terrorist activities, their victim status, the fact that does not disappear, right? So they were kidnapped with their children, and so they shouldn't be prosecuted. And I think this is why it's important that when we talk about building capacity and training, part of the training needs to be taking that human rights centered approach to the investigation and prosecution to understand whether the perpetrator was a child at the time the crimes were committed. So I want to emphasize that part because I know people are very aware of the Ongwen case and the decisions that came out recently. And so the point is not about crimes that the person committed eventually as an adult, but as a child or as a victim of trafficking or kidnapping, and we're being compelled to act in a certain way. And so it's important then that, you know, all those who are involved in the system, the criminal justice system, have that human rights centered approach to be able to properly assess and analyze the case so that you're not wrongfully or further victimizing the victim just because they had engaged in terrorist activities against their will.
Thank you. A pretty somber and sober note to close us out here. So thank you to all our panelists, to all our participants, to those who have been following along online. We urge you to continue to follow the research that we're putting out in this area in terms of accountability and other aspects, and to follow our work on the SoufanCenter.org, our daily intel briefs, and other publications. So thank you very much once again, and we look forward to seeing you at some of our events in the future. Thank you.